Be ready. 5 seconds. Start. This appeal takes exception to the judgment and order dated 2nd January 2017 passed by the High Court of Delhi at New Delhi in RSA number 391 of 2016, whereby the High Court affirmed the decision of the Court of Civil Judge allowing the application filed by the respondents/defendants for rejection of the plaint under Order 7, Rule 11 of the Code of Civil Procedure 1908 instituted by the appellant/plaintiff stop. The additional district and sessions judge wide order dated 23rd July 2016 in RCA number 61794 of 2016 had also affirmed the order of rejecting the plaint stop. The appellant had filed the stated suit on 23rd February 2005 for a decree for rendition of true and correct accounts in respect of the interest/commission charged and deducted by the respondent bank relating to current account number CCM 20225 of the appellant for the period between 1st April 1997 and 31st December 2000, and also for recovery of the excess amount charged by the respondent bank consequent to rendition of accounts with interest at the rate of 18% per annum from the date of deduction, including interest, pendentolite, realization of the amount, and future interest stop. The plaint came to be rejected by the trial court under Order 7, Rule 11D of the Civil Procedure Code on the ground that it was barred by law of limitation as it was filed beyond the period of 3 years prescribed in Article 113 of the Limitation Act 1963 as applicable to the present case from the date when the right to sue accrued to the appellant in October 2000 stop. The entire discussion of the trial court in that regard can be traced to paragraphs 10 and 11, which reads thus: para. As stated above, the plaintiff, by way of present suit, has sought two reliefs, that is, rendition of account and repayment of excess money stop. Limitation Act 1963 does not provide any specific article with regard to time period within which accounts can be sought by party from its bank stop. As such, Article 113 of Limitation Act came into picture, which provides a limitation period of 3 years for suits for which no limitation period is provided from the date when right to sue accrues stop. In the present case in hand, as per averments made by the plaintiff in his plaint, the facility was availed by the plaintiff from the defendants till October 2000 stop. Further, as per averments made in the plaint, the alleged amount so charged by the defendant from the plaintiff in excess from agreed amount was till October 2000 stop. As such, at best can be said right to sue accrues in favor of the plaintiff in October 2000 stop. Considering the law as stated in above paragraph, plaintiff could have filed the present suit, that is for rendition of account and repayment of excess amount till October 2003 stop. After so observing, the trial court considered the submission of the appellant that the cause of action had accrued to the appellant only upon rejection of the representation by the respondent bank entailing in refusal or denial of liability communicated to the appellant via letters dated 19 September 2002 and 3rd June 2003, and after the final legal notice was served upon the respondents on 7 January 2005, stop. That contention has been rejected by adverting to the decision of the same High Court in C.P. Kapoor versus the chairman and others, wherein it is held that exchange of correspondence between the parties cannot extend the limitation period for institution of a suit once the right to sue had accrued, which in this case had accrued in October 2000, as has been asserted even in the plaint. Stop.